I'm Patrick Apple, a criminal defense attorney here with Fradin in our Greensboro office. Larceny is a legal term for theft or stealing. A larceny occurs when one person takes and carries away the property of another that the other had the right to possess. They didn't even have to own it. And that person that takes and carries away the property did it with the intent to permanently deprive them of the use of that property, knowing that they were not allowed to possess it. Larcenies are Class 1 misdemeanors in North Carolina. That's the second highest misdemeanor there is in North Carolina. They can result in active sentences. Even a charge itself of larceny without a conviction does look bad on a criminal record. Employers, when they're doing background checks of potential employees, are looking for trustworthiness and someone that they can trust to handle their property, their money, their finances, their information. So they're going to look for truthfulness. A larceny charge often goes to truthfulness. I've seen it in my own clients' experiences where they have even just a charge itself has kept them from valuable jobs. Larcenies are one of the most common crimes charged in North Carolina. They're typically brought in relation to big box chain stores such as Walmart, Target, other things like that. They often occur around self-checkout where people change the price tag. That's a different type of larceny, or shoplifting. That's another type of larceny. Oftentimes, law enforcement does not even personally observe a larceny occurring, but the charges still occur. Stores have a loss prevention staff whose job it is to monitor potential larcenies. What they will do is often stop you, ask you to make a statement, and then that statement will be given to law enforcement, and that's where the charge is going to result from. The Fifth Amendment protects you from having to make any statement against your self-interest. I would advise not speaking to any law enforcement personnel or loss prevention officers or any non-attorney about any criminal matter without an attorney present. Any statement you make to loss prevention or law enforcement can be used against you at trial and often will be one of the central pieces of evidence against you in a larceny. If I never made a statement to law enforcement and law enforcement never even saw me take the property, can I still be prosecuted for a larceny? Unfortunately, yes. The loss prevention officers or the witnesses to the larceny can still appear and testify against you in court. Now, the Sixth Amendment gives you the right to confront any witnesses against you. So it's important that you speak to an attorney to make sure the state has all the correct witnesses there. An employer or a big box chain store cannot simply rely on a recording that has not been authenticated as evidence against you. There's best evidence concerns as well as confrontational concerns that may violate your Sixth Amendment right. It's important to have an attorney present to make sure that there's proper objections to any evidence that should not come in against you.